This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Professor Jorge Contreras to the show. Professor Contreras is an award-winning legal scholar, currently a professor of law at the University of Utah, where he teaches transactional law. He's a prolific author and sought-after expert witness. Professor Contreras holds a JD from Harvard. Professor Contreras, thank you so much for joining me here today at the Roundtable.
Oh, it's my pleasure. Thanks for inviting me.
Of course. Let's jump into it. With an impressive career as an attorney before moving into academia, you must have had occasion to work with expert witnesses a lot. Let's get into the initial call. What are attorneys looking for when they are first vetting expert witnesses, and what should experts be aware of?
Yeah, so as it turns out, when I was in practice, and I did spend 17 years in practice at a large international law firm, I was a transactional lawyer. And so I didn't hire experts. I really only got exposed to the world of expert witnesses after I resigned from my firm to become an academic, and then started doing it as the expert rather than the attorney.
Oh, how interesting. Tell me about your first engagement as an expert.
I'm not sure exactly what my first one was, but one of the earlier ones was serving as an expert for the Internal Revenue Service in one of its large transfer pricing cases against a U.S. taxpayer, Amazon, with respect to its international licensing and subsidiary arrangements around the world.
So tell me about that, the vetting process. You get the call, and what is it like? What are they looking for in you? And then what are you looking for in an attorney, whether, to decide whether or not you're going to accept the engagement?
Yeah, so my understanding of what they're looking for is someone who, A, is truly an expert, right, knows the material, that some level of detail that can be demonstrated, through publications or other work, talks, and so forth. I think they also want someone who is articulate, right, who can explain whatever this is to a layperson, really, whether it's a jury, but more likely a judge or an arbitrator in some of these complex cases. There's an interesting consideration of how much expert experience someone has. And what I learned from going through this process the first time is that often attorneys aren't looking for someone who's been an expert 50 times, right? Because that smacks of someone who is sort of a professional expert as opposed to an actual expert in their field. So I probably have appeared formally as an expert witness like 10 times, so it's not that much, but in some pretty significant cases. So so it's been fun. Now, what I'm looking for as the expert is, obviously a reputable employer. Usually I've been hired by outside law firms, but in some cases I've been hired directly by the client, the IRS, for example. I was hired by their in-house counsel. They managed the litigation for this, and there was another transfer pricing case against the Coca-Cola company that I also was an expert for the IRS. And all of that was handled in-house. But most of my other engagements have been through outside counsel. And, but I want someone reputable. And I also, am looking for a case in which I agree with whatever the position is. I mean, that should seem obvious, but so I've definitely turned down expert engagements where I didn't feel like I could convincingly take the position that would benefit whatever the client was.
Do you typically have enough information during those initial phone calls to make that determination?
Yeah, generally. And in fact, the attorneys who are hiring you also want to make sure that you share their view of the world. In some areas, it's clear, like from my academic writing, what my position is in certain, in certain issues. But it's not always the case, and some issues are very narrow issues that haven't really come up before, and so you have to kind of think about it from scratch and decide, whether or not it's something you'd be comfortable with.
Well, with academic writings, it's a great jumping off point because I'd like today's primary topic to be about report writing, expert reports. You are in academia, so you have seen your fair share of writings, not to mention having written a lot yourself. You are a prolific writer. What makes a good writer, and to what extent does that translate to good expert report writing?
Any kind of writing, my view is the idea is to explain whatever the subject matter is in an understandable way that is not full of jargon, right? That is simple and direct and should be understandable by someone with, some knowledge of the subject. Um, and again, I try to achieve that in my academic writing, my writing for broader audiences, blog posts, and so forth, and expert reports also.
Is there a specific method or strategy that you use to format expert reports so that they're either readable, to yourself, so that you can refer back to them, potentially during a jury trial or deposition, or do you just kind of write off the cuff? What's your strategy with formatting?
I do expect that I'll have to consult my report during testimony, usually. I mean, I try to organize it, by topics. I'm usually asked to answer some specific questions. And so, generally, there's some background, and then I just go into answering the questions. And that's really all that there is to it in terms of, the organization and the formatting of the report.
Do you use any kind of glossary or appendices or anything like that if you have kind of a longer report?
No, I never have. And some of my reports have been quite long, and I usually define things, in line as we go along.
We were talking about making sure that you can communicate complex subjects to laypersons. What are some of the techniques that you use to do that, assuming that you have kind of a long, complex topic that needs to be described to people that potentially know nothing about your field of expertise?
Yeah, I really try to distill down whatever the concepts are. I make sure that whatever the point is that I'm making, I've explained, all of the antecedent information that you need to understand what the point is, but again, in a way that's straightforward, in a way that doesn't assume a lot of prior knowledge. And again, this is just as applicable to judges as it is to juries. Juries don't read reports. Right, juries only hear testimony. Um, so, I try to lay it out very clearly, sentences that aren't overly long. If I use some term of art, I define it and try to use it consistently, but I try to avoid as much of that as possible. It's not always possible, right? You've got to use some technical terms in these, but I just try to lay out all the antecedents, and make sure that it I explain it in a straightforward way.
A lot of experts, have a very deep knowledge of their area. And when asked, they kind of want to really expound upon everything that they know. How do you remain concise and stay kind of within the four corners of the matter without, going into irrelevant areas?
No, I don't have a strategy, and I don't always succeed in doing that. There are definitely times when the attorneys who, I share drafts with them as we go along, and they say, could you just cut out this, and this, and because it's not really germane to the case. And so I'm happy to do that. They know best, I think, how they're trying to frame their case. And as long as, they're not asking me to say anything inaccurate, I'm happy to, remove excess stuff that they don't think is relevant.
Considering confidentiality and discoverability, do you have any editing techniques that you use?
Yeah, from the standpoint of me as the report writer, I usually don't have all that much, right? Or what I have is the parts of the record that counsel have given me, and the parts of the record generally are open to the other side. Um, and so I'm also, another piece of this is when I write a report, I try not to make it sound like a brief, right? I try that's the job of the lawyers, right? I'm not there to make an argument on behalf of a party. I'm there really to educate the court, or the jury, whoever it is who's making the decision about the, what the industry norms are, how different processes work, what the law is, if I'm writing, if this is a matter in a different country. And so I, no, I generally, anything that I say, is open to the other side. It's there for the other side. I don't, there's, I generally, again, I'm not part of the counsel team. And I do feel, that sometimes they're not necessarily telling me everything about the case. But that's okay. I'm just answering their questions, and I'll answer to the best of my ability.
You talked about a back and forth between you and the attorney. I have a couple questions about that. First off, do they provide you with any kind of like a skeletal outline or anything like that before you get your report started? To what extent are they involved in starting, editing, doing any writing any content in your report?
Yeah, generally, no. I mean, that's not my style of work. I know that some experts will do that, and I've heard, and counsel have told me about how they're experts who, the attorneys just write their report, and like they maybe make some tweaks and then sign it. I write my own reports. Um, it's a matter of my style, but also, the expertise that I'm being hired to provide. I mean, that's not to say though, then when I write a draft, then the attorneys and the clients will review it. They'll often want me to, go into more depth in one thing or another. They'll say that these, certain things seem extraneous and, don't need to be there. Often they'll read what I've written and say, oh, actually we need to give him some more facts, and they'll provide me, more pieces of the record, or, deposition transcripts from the other side that have been taken, while I was writing the report, right? It's all happening kind of in real time. So, so there's definitely interaction, but, by and large, though they'll ask me questions, and we'll talk about how they frame their questions, and I'll often state what the questions are at the beginning of the report. Beyond their questions, I generally write it.
Have you had experience working both on the plaintiff and defendant side as an expert witness?
Well, they're definitely. I mean, whether you're the plaintiff or defendant, though, you always start with an opening report, or at least I always have.
Okay.
And then rebuttal reports, and re-rebuttal reports and so forth. You can go on and on. Um, your opening report, you state your view of the facts, the law, whatever it happens to be, in a kind of complete way. The rebuttal report, you're simply responding to the opposing expert's report, and so there you just point by point out the flaws or points that you disagree with in that other report. So it's much less narrative. It's really just kind of a point by point rebuttal. Whereas the opening report, it can be a narrative. It should have some sort of logical flow to it, whether it's chronological or topical or whatever.
Have you worked on kind of a team with other expert witnesses?
No, I haven't. I mean, I've certainly, most of the cases that I've been involved in have other experts working for the same side, and sometimes I've been given their reports, or pieces of their reports to inform what I'm writing. But counsel, I think, like to keep control over this process, and I think they don't like the experts to just get together and go off and do their own thing. I think they really want to be in control of who's doing what and which pieces of this case they're presenting.
So, as somebody with experience both as an attorney and an expert and a professor, do you think that that's wise? Is it better to allow the experts to interface, or is there, is that caution warranted?
Yeah, as an attorney, I can definitely see where you don't want the experts going off and going down their own path. It's the attorney's case, right? They're making the case, and the experts are supporting that case in some way, but they really need to be in charge of the overall strategy.
Are there any other common pitfalls that you've seen vis-a-vis expert witness reports? Anything else?
Oh, there are all kinds of potential pitfalls. You know, um, you don't want the so some attorneys are more proactive than others in commenting on the report, and some will want to mark it up and try to put words in your mouth, and that's something that really should be avoided, right? At the end of the day, you as the expert, you're going to have to defend the words in that report in deposition and possibly in testimony, and you really want to be comfortable with everything that's in it. And so, other than allowing the attorneys to put the right references to the exhibits that they come up with and so forth, I think you should resist allowing the attorneys to tinker too much with your report. That's what their briefs are for. They can write their briefs in the way that they want.
So you might recommend taking a little bit of a proactive role, and if you you see the attorney trying to push you, too hard in your opinion, to push back against them a bit.
Oh yeah, I mean, I'd say I just don't think I'd say it that way, or that's not really like my style. So I think that's fine. I think they respect that.
Beyond the reports, I have a couple other topics I'd love to touch on with you. Let's talk about venues a bit. Have you worked in different venues, for example, state, federal, regulatory, international, etc., or have you primarily worked in a single venue?
No, it's been a wide variety, interestingly.
So, what are some of the differences, especially from the viewpoint of expert witnesses, but also broadly? What are some of the differences in working across different venues?
Yeah, well, as the expert, you don't have to be familiar at all with the actual procedural rules, although there are ethical rules and rules about experts that are different in different countries. I mean, so
Hmm.
I've served as an expert in the U.S. Before like courts, International Trade Commission, uh, but also in courts and tribunals in the UK, in Germany, in Brazil, Um, I think that's it. There may be more. It is the main difference. I'm a lawyer. I'm licensed to practice law here in the U.S., but in the U.S., an expert is not supposed to opine on the law, right? Not
Hmm.
on U.S. law.
Right.
That's the role of the judge is deemed to be an expert in the law, and the counsel are there to make the legal arguments. So in the U.S., as an expert, as a lawyer, I can opine as to industry practices that I'm familiar with, and that's kind of it.
Sure.
Um, and one exception is, in the tax court where I have done a significant amount of work, where the tax judge and the counsel really don't have expertise in intellectual property law, and aren't expected to, because the tax court, and that's my area of expertise. There, I was engaged, and much of my focus was basically to educate the court as to U.S. intellectual property law and international intellectual property law. But that's an exception. In most courts of general jurisdiction, district courts, or administrative law judges at the ITC, they're assumed to have that knowledge. Whereas in a foreign court, generally my job as an expert is to educate that court about U.S. law,
Huh.
right? So I am giving an opinion about what U.S. courts have done in the past, how they consider issues, what U.S. law is, right? And sorry, Canada, I forgot, is another jurisdiction where I have served in that kind of role.
Is it that U.S. law is somehow persuasive there, or is it that you're working in actions that somehow have touch the U.S. law in some way, shape, or form?
Yeah, yeah. For the most part, the types of cases that I'm involved in are multinational, multi-jurisdictional cases where
Wow.
there is some relevance of U.S. law to what's going. In fact, I'd say probably all of them.
Wow.
Um, there's a matter, and the U.S. matter may have gone first. The U.S. matter may be going on concurrently, and so the foreign court needs to know certain things. Also, the foreign court is often deciding whether or not it should take jurisdiction over a case, or whether it should stay its own proceedings in view of what's happening in the U.S. And the U.S. courts are sort of making the same decisions. So it's important for the foreign court to know sort of what the procedures are, what the decisions are in the U.S. from an objective expert who is not, counsel
Right.
to one of the parties. Um, in some cases, the foreign court will be applying U.S. law, just like a U.S. court hearing a case that involves some contract governed by Swiss or Swedish or French law. And the U.S. court will look at expert testimony to see what Swiss law is on this question, and then the U.S. court will apply the Swiss law. And so in a foreign court, I would be an expert opining to the foreign court on what U.S. law would be.
Are you typically brought in early enough in the process to properly prepare for something like that? It sounds like there's a lot of preparation work that would go into being able to opine from a position of authority in a foreign nation like that.
Yeah, yeah. The timing has to work, with my schedule. I uh, I do have a sense for how long these things will take. I mean, the good news is I am an expert in many cases that are in the same general area of the
Sure.
law, and I know that area pretty well. And so, I really have much of the preparation is I don't have to learn this stuff from scratch.
Sure.
Um, but of course, I mean, things keep changing, and every case is different. So there's still preparation that I have to do in every case.
as a triple threat, an attorney, an expert, and a professor, what makes for a positive attorney expert relationship? What are the aspects that make a winning team?
Oh, so from my standpoint, from the expert standpoint, having attorneys who are communicative, who will lay out deadlines, explain them, will get back to you quickly with feedback. Those are all really good things. These cases, all sorts of twists and turns occur. There are delays and so forth. And sometimes you end up sending a report or a draft report, and then you don't hear back for weeks or months, and you have really no idea what's going on. So, as an expert, I really appreciate it when the attorneys keep me posted. It's like I'm not going to bill, 0.1 hour for reading your email that, updated me on the status of the case. It's just nice to know for scheduling purposes, if nothing else. So, as a good communication is really useful and much appreciated.
Are there billing considerations that make a relationship more positive? Setting those expectations in advance, following best practices, anything like that regarding billing?
Being paid promptly is a big plus. Um, one issue that maybe sometimes comes up is that the law firm, if you're hired by a law firm, the law firm often will not pay you until they receive, they submit your bill to their client, then
Sure.
their client pays them, and then the law firm doesn't pay you until that happens. And so you've got a lot of billing cycles in between issuing your invoice and then actually receiving payment. And, sometimes that's a little bit unnerving because you can rack up 3 or 4 months of work between, the month that it takes them to process your bill, send off to the client's sitting on the bill, not paying it, and they're not necessarily chasing it. It can take a long time. And so when it looks like I've got a fair amount of work done and haven't received anything yet, I do nudge the counsel sometimes. And if it's getting to be a large amount of money, the counsel sometimes will be generous enough to just pay it out of their firm, and then not wait until they collect it from their client, because like with their client, my expert time is like only a drop in the bucket. There's all the
Sure.
other experts and expenses and the lawyer time and so forth. And you know, it it so I've had a few occasions where the clients are just slow, especially foreign companies dealing with U.S. law firms. They don't necessarily pay that promptly, and then I am sitting there like at the back end of another 2 billing cycles, waiting for that. So interestingly, I've been an expert in a couple of contingency fee cases,
Hmm.
uh, still like patent or antitrust cases. And
Sure.
the contingency lawyers, they don't have to wait for payment. They've just got funding from funding source, and they actually pay very promptly. So that's nice. It's the big multinational firm that's representing a foreign offshore client who is a slow payer that sort of it gets stretched out a bit, and that is a little unnerving.
Can retainers help mitigate some of those issues?
Yeah, they could, but I have not really done many retainer. Maybe I should, maybe if I were a better business person, I would. But it's really hard to figure out how much a retainer ought to be. And
Sure.
so, I generally just go on an hourly basis, and you know, again, the firms that I deal with are all pretty large firms, name brand firms, and and at the end of the day, pretty much trust that I'll get paid. But
Eventually.
you know, I always have. I've never truly been stiffed
Right.
on the bill.
Well, let me ask you. It's interesting you brought up that occasionally, or maybe even often, firms will make your payment contingent on when they are paid by the client. Is that fair? Considering that the attorney ultimately is your client, not the end client. Should when you are paid be related to when the client pays them, given that their client is not ultimately yours?
I would say absolutely not. But that is almost always a part of the firm's engagement letter with
Interesting.
me anyway. Maybe I'm not negotiating hard enough, but that's their policy usually.
Before we wrap up, do you have any last advice for experts, and in particular newer experts?
I would just say, do a really good job. The experts. I mean, so there are you definitely can get expert work from like the expert group and bureaus, but by and large, I get work based on referrals.
Hmm.
And it's and I have even just recently, like in the last month, had a firm considering hiring me asked for a reference, from other law firm who had worked with me. And so, I would definitely try to do your best work, not just, do the work to get the bill. If you want additional expert work, a lot of it is going to come from future referrals. So I would, just try to do your best job and keep a good relationship with the, with the counsel. The counsel are the ones who are going to come back and hire you. And I've been hired on a repeat basis by some law firms. And so keeping those good relations is the most important thing.
Thank you so much, Professor Contreras, for joining me here today at the roundtable.
Hey, absolutely. No, this is fun. Thanks for having me.
Absolutely. And thank you to our listeners for joining me for another discussion at the roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.